this is just one more reminder of what we've always known, that child marriage is a human rights abuse that destroys almost every aspect of a girl's life, and it leads in most cases to really heartbreaking and devastating consequences.
On the 31st of March 2008, a 15-year-old girl got into a car in Ohio and was driven across the state line into Mason County, West Virginia. She was 7 months pregnant. And at a courthouse in West Virginia that day, she was married to an 18-year-old man. Here is a detail that should stop you. They did not drive to West Virginia by accident, or for a view, or because that is where the family was from. They drove there because in the state of Ohio, what they were about to do was illegal. Ohio would not let a 15-year-old marry. West Virginia in 2008 would, as long as a parent said yes. So a parent said yes. And a child became a wife one county across a border because a border was the only thing standing between against the law and perfectly legal. That girl was Elizabeth Siders. 2 months after the wedding, she gave birth to the first of what would eventually be 18 children, and 18 years later, 16 of those children were carried out of a house in Vinton County, Ohio, and 4 adults, Elizabeth among them, were charged with endangering them. If you have followed this case with us, you know that house. Tonight we are going to leave it and drive back across that state line to 2008. Because we have spent 6 episodes on what happened inside those walls. Tonight we ask something none of them could, not what happened to those children, but what made that wedding legal in the first place, and whether the law that stamped the paper on a 15-year-old is still on the books today. It is, and there is a bill sitting in a building in Columbus right now that would end it. It has been sitting there, going nowhere, this entire time. Before we go further, this episode deals with child marriage, abuse, and the exploitation of minors. I won't show or sensationalize anyone, but if this is heavy for you, take care of yourself while watching. If you're new here, this is Quiet Record. Verified reporting, named experts, nothing invented. Subscribe if that's what you want. Tell me in the comments where you're watching from, and to everyone who's followed this case across 6 episodes, you're the reason it's still being asked about. Thank you. Because tonight the story steps back from the house and looks at the law, and the law, it turns out, is the part of this that could actually be changed if anyone in Columbus decided to change it. Let's start with the drive across the border because it is the whole case in miniature. In 2008, Ohio and West Virginia had different marriage laws, and Elizabeth's family knew the difference well enough to use it. In Ohio, a 15-year-old could not legally marry, full stop. In West Virginia at that time, a 16 or 17-year-old could marry with parental consent, and someone younger than 16 could marry if a judge approved it. Elizabeth was 15 and pregnant, so West Virginia was the door that opened. They crossed one county line, got the parental sign-off, and made it legal. That is not a loophole in the sense of a trick. It is a feature of how marriage law works in America. Marriage is regulated state by state, and the states do not match. Which means that for a determined adult, the age of a child bride is not really set by any single law. It is set by whichever neighboring state has the lowest bar and a willing parent. A border becomes a tool. Now here is what most people watching this do not realize, and it is the reason this episode exists. That crossing happened in 2008, but the law Elizabeth crossed a border to escape, Ohio's, has itself changed since then, and the law she crossed into, West Virginia's, has changed too. So let's be precise about where things actually stand in 2026, because the story is not as simple as, that could never happen now. Take West Virginia first. In 2023, West Virginia changed its law. Before that, 16 and 17-year-olds could marry with parental consent, and under 16s could marry with a judge's approval, the exact framework that let Elizabeth marry at 15. Now, West Virginia sets the marriage age at 18, but with an exception, a 16 or 17-year-old can still marry if they get parental permission or petition a court and affirm the marriage is voluntary. So West Virginia tightened the floor, no more 15-year-olds, but it did not close the door completely. Now Ohio. In 2008, Ohio's law was actually strict enough that Elizabeth had to leave the state. Ohio has since reformed its own law too. Today, in Ohio, the minimum marriage age is 17. A 17-year-old can marry, but only with parental consent, and only with the approval of a juvenile court, and there are conditions attached. The age gap between the minor and their intended spouse cannot be more than 4 years. There is a waiting period. A guardian may be assigned to the minor. It is, by design, a set of hoops. So on paper, Ohio in 2026 looks better than Ohio in 2008. A 15-year-old cannot marry here now, but, and this is the pivot of the entire episode, 17 is not 18. And to the people who study this for a living, that 1-year gap is not a technicality. It is a door that is still open. It is the door this next part of the episode walks through. Because a woman named Fraidy Reiss has spent years arguing that as long as that door is open even a crack, children are walking through it and being harmed on the other side. If you've been with this case, this is where I ask the one thing that keeps this channel doing what it does. What you're about to hear, the actual mechanics of child marriage law, from the people fighting to change it, is not the viral part of this story. It doesn't trend. But it is the part where a viewer can actually do something, because unlike a sealed court file, a bill in a legislature responds to public pressure. Subscribing is how you keep coverage like this in your feed. One tap. Then stay with me, because the expert I'm about to introduce did not study this from a distance. She lived it. Fraidy Reiss is the founder of an organization called Unchained at Last. And before she founded it, she was, in her own words, forced into a marriage at 19 to a stranger in a fundamentalist religious community in New York, a man who turned out to be violent. She was trapped in that marriage for 15 years. When she finally escaped, her family and community retaliated by shunning her completely. They declared her, in her telling, dead. Nearly 20 years later, she says, they still consider her dead. Out of that, she built Unchained at Last, first to help other people escape forced marriages, and then, when she realized how many of the people asking for help were children, to change the laws that trapped them. And Reiss makes an argument that is, at first, jarring, but follow it, because it is the intellectual core of this whole fight. She argues that any marriage involving someone under the age of 18 is, by definition, a forced marriage. Not sometimes, always, even if the minor says yes, even if the minor insists they want it. Here is her reasoning, and it is not sentiment, it is legal mechanics. A person under 18 does not have the full legal rights of an adult. And without those rights, Reiss argues, a minor cannot actually refuse a marriage, which means they cannot truly consent to one either. Think about what a 15 or 16-year-old cannot do. They cannot, in most states, leave home on their own. Running away is itself a status offense. They cannot independently check themselves into a domestic violence shelter. They usually cannot retain their own attorney because contracts signed by minors are voidable. So picture a 16-year-old whose parents have arranged a wedding she does not want. What can she actually do to stop it? She cannot leave. She cannot get herself to a shelter. She cannot hire a lawyer. Reiss's point is devastating in its simplicity. If you cannot say no and make it stick, then your yes means nothing, and a yes that means nothing is not consent. She draws the comparison directly to statutory rape law, and it is the cleanest way to understand her argument. We already accept as a society that a child below a certain age cannot consent to sex, that even if the child says yes, the law treats it as rape, because the child lacks the legal capacity to truly agree. Reiss is saying, apply the same logic to marriage. A child too young to hold the rights of adulthood is too young to consent to a marriage contract, no matter what words come out of their mouth. And a marriage entered without real consent, she says, is a form of modern slavery. And here is the fact that reframes this from a fringe concern into a national one. When Reiss's organization began this work around 2015, child marriage was legal in some form in all 50 states. Every single one, not a historical footnote, current law, a decade ago, coast to coast. Since then, going state by state, the movement has helped ban child marriage in 17 states, the District of Columbia, and 2 U.S. territories. Which sounds like progress until you do the subtraction. That means roughly 33 states still allow some form of marriage under 18 today, in 2026. And some of the holdouts are not the states you would guess. Reiss points out that California, a state that markets itself as one of the most progressive in the country, has, by her account, no statutory minimum marriage age at all. There are consent requirements and court steps, but no hard floor written into the law. In 2026, in California, there is no number below which the law simply says no. So this is not a red state or blue state story, and it is not an Appalachia story, however much this particular case sits in the hills of southeast Ohio. It is a 50-state patchwork, and Ohio is one square in it. A square where, right now, the number is 17, and a bill to change it to 18 is sitting untouched. That phrase, modern slavery, is not hers alone. The U.S. State Department has described child marriage as a human rights abuse. And I want to be careful and precise here, the way this channel always tries to be. Fraidy Reiss is describing child marriage as a category, the practice, the law, the millions of cases worldwide. She is not standing in a courtroom testifying about what did or did not happen inside one specific family in Vinton County. What Elizabeth Siders experienced, what she understood, what she wanted or did not want at 15. That is a question for the people who know the facts of her life, and it is a question this case may never fully answer. Reiss's argument is about the rule, not the defendant. But the rule is what made the defendant's marriage possible, and that is worth sitting with. Because Elizabeth's marriage, it turns out, may not have been the only one in this family. Reporting by the Columbus Dispatch, whose journalist Laura Bischoff has covered this case closely, has documented that Elizabeth's marriage at 15 was not an isolated event within the extended Siders family. The Dispatch has reported additional instances of early marriage among relatives, including a cousin connected to the family who also married a girl of 15. Taken together, the reporting describes a pattern of teenage marriage across more than one generation and more than one branch of this family. At least 3 such marriages that reporters have been able to document. I want to flag something honestly here. Some of the most extreme specific details circulating about these family marriages, particular ages, particular pairings, trace back to a columnist's recollection of an old interview and have not all been independently confirmed in the public record. So I'm going to tell you what the careful reporting supports. Multiple teenage marriages across the family over years, including Elizabeth's own at 15. That much is documented. The lurid specifics beyond that, I'm going to leave to the reporters who can actually stand them up, rather than repeat numbers I can't verify. What matters for this episode is the pattern, because a pattern is what a law is supposed to catch, and this one didn't. Which brings us, finally, to the bill. The one sitting in Columbus. The one that could close the door. It is called Senate Bill 341, and what it does is simple enough to state in a single sentence. It would set the marriage age in Ohio at 18, with no exceptions, no parental consent path at 17, no juvenile court approval, no 4-year age gap allowance. 18, or you wait, that's it. The bill's sponsor is an Ohio state senator named Louis Blessing, and when Blessing talks about this case, he does not talk about it the way a true crime audience might expect. His reaction, in his own words, was the same shock everyone in Ohio felt, but the thing that gripped him was the system's failure. How, he asked, Could you have that many children and there be no record of them? There were births in hospitals. There were birth certificates. There should have been tax records, school enrollments. His conclusion was that Ohio's agencies do not talk to each other, that a truancy complaint in one county and a stack of birth certificates in another and a set of tax filings somewhere else all sat in separate silos, and no set of human eyes ever put them together. He has floated using data matching, even artificial intelligence, to flag exactly these kinds of anomalies. Dependents claimed on a tax return, births on record, and yet no child in any school district. A red flag that a human being could then go check. That is a different lens than we have used in 6 episodes, and it is worth holding because it connects the marriage to the hiding. The same invisibility that let a family conceal 16 children is the invisibility that lets a 15-year-old marriage disappear into the gap between 2 states' record systems. Blessing's argument is that the failure is structural and structures can be fixed. But here is the part that should genuinely frustrate anyone watching. Senate Bill 341, this simple one-sentence bill, is stuck. It passed its committee, and not narrowly. It passed committee unanimously. In the public hearings on this bill, according to its supporters, not a single member of the public testified against it. Dozens testified for it. It costs the state nothing. It takes nothing away from anyone who is already an adult. And it would end what the federal government itself calls a human rights abuse. And it is sitting on the Senate floor, unvoted on, going nowhere. Why? The resistance when you go looking for it is strange and thin. Some legislators have raised the idea that banning marriage for pregnant teenagers might, somehow, lead to more abortions. The notion being that marriage is a solution to a teenage pregnancy. Others have leaned on parental rights, that a parent should be able to consent to their child's marriage. And at least one senator has objected based on personal or community experience, pointing to relatives who married young and turned out fine, or to communities where early marriage is a tradition. Reiss has an answer to the turned out fine argument, and it is worth hearing in full, because you will encounter this argument in your own comment section under this very video. Yes, she says, some people who married as minors turned out fine. But research consistently finds that a large majority of marriages entered before 18 end in divorce. She cites figures in the range of 70 to 80%. The people who married young and thrived are the minority who escaped the statistical trap, not proof that the trap isn't there. And, she argues, the fact that you know one person for whom it worked out is not a reason to leave every other child exposed to the harm, the lost education, the economic damage, the elevated risk of domestic violence, the legal trap of being bound by a contract you did not have the adult rights to negotiate. Senator Blessing makes a version of the same point from the other side of the aisle, and more bluntly. His answer to, "What's the rush?" is, there is no rush, and that's exactly the point. You have to be 18 to sign almost any other binding contract. Marriage is a contract, one of the most consequential a person ever enters. Why, he asks, would we treat this one contract as the single exception where a child can be bound? He runs through everything a married minor still cannot legally do: vote, drink, rent a car, enter most contracts, while being locked into the one contract that reshapes an entire life. When you get married, he points out, you are in many ways legally emancipated from your parents. So, the parental rights argument eats itself. The parent signs the child into a marriage, and the signature is the very thing that removes the child from the parent's protection. Blessing also puts this particular case in a historical frame, and it is worth following because it cuts against a lazy assumption. There is a temptation to look at a 15-year-old marriage in Appalachian Southeast Ohio and file it under, "That's just how it's always been out there." Blessing pushes back on his own region's stereotype. Yes, he acknowledges, if you go back a century, teenage marriage was more common across rural America, often tied to pregnancy. But he is blunt that this was not 1908. Elizabeth married in 2008. This is not a faded photograph from a bygone era. It happened in the age of the smartphone, and it happened because a modern law in a modern state still allowed it. The "it's tradition" defense, he argues, is a way of dressing up a present-day harm in nostalgia, and he wants it stamped out precisely so it becomes what people wrongly assume it already is, a relic. He also names something uncomfortable about the resistance. The opposition to this bill is not a powerful, organized lobby. There is no coalition packing the hearing room to defend child marriage. It is, instead, a handful of individual legislators with idiosyncratic objections. A personal anecdote here, a hypothetical about pregnancy there. Enough, in a legislative calendar crowded with other priorities and interrupted by recess, to keep a bill with unanimous committee support and zero public opposition from ever reaching the floor. That is how these bills die, not in a dramatic defeat, in a slow suffocation of scheduling where a thing almost everyone agrees on simply never comes up, session after session, because no one with the power to call the vote decides it is worth the floor time. And that is the quiet scandal underneath the loud one. The house in Vinton County made national news. The law that helped make that family possible cannot get 15 minutes on a Senate floor. Reiss has a sharper way of putting the stakes for Ohio specifically, and it is one every Ohio resident watching should hear. Because Ohio has not yet closed its door, and because Pennsylvania, and every state to Ohio's east and north, already has, Reiss warns that Ohio risks becoming what she calls a destination state, meaning, if you are an adult who wants to marry a minor, and your own state has banned it, you look at the map for the nearest place that still allows it. The way Elizabeth was driven across one line into West Virginia in 2008, a determined adult today looks for the state still holding the door open. As its neighbors close theirs one by one, Ohio moves up that list. A law that stays at 17 well moves and doesn't just fail Ohio's own children. It advertises to the surrounding region that Ohio is where the paperwork can still get stamped. And then there is the piece of this that reaches beyond Ohio's borders entirely, the part that turns a state marriage law into a national security question. Because Reiss argues that the 17-year-old door isn't just a domestic problem, it's an international trafficking loophole. Here is the mechanism, and it is precise. The United States federal government does not set a minimum age for a spousal or fiancé visa. Instead, it defers to the marriage law of the state where the couple intends to live. So follow the logic. If Ohio law says a person can marry at 17, then as far as federal immigration is concerned, a 17-year-old in Ohio can be married for a visa. Which means, Reiss argues, two things become legally possible. A 17-year-old girl in Ohio could be married off and taken overseas, trafficked out of the country under the cover of a marriage, or, in reverse, an adult man in Ohio could import a 17-year-old bride from anywhere in the world, bringing a child into the United States under the guise of marriage, entirely legally, because Ohio's marriage age made it legal. Reiss points to a report from the U.S. Senate Homeland Security Committee finding that thousands of teenagers have been brought into or moved through this visa system under the guise of marriage, the overwhelming majority of them girls married to adult men. I'll be straight with you about sourcing. I could confirm the mechanism and the broad federal findings, but the exact figures in that specific Senate report are something I'd want you to see at the primary source before you treat any single number as gospel. What is not in dispute is the structure. Federal visa law defers to state marriage age, and a state that allows marriage at 17 is a state that has, without intending to, left a door open that traffickers can use. Raising the age to 18, no exceptions, is what slams that door. That is Reiss's entire argument for why this is not a small bill. So here, as of this recording, is the honest ledger. What is true? Elizabeth Siders married Gary Siders Jr. in Mason County, West Virginia, on March 31, 2008, at age 15, while pregnant, because Ohio law at the time did not permit it. West Virginia changed its law in 2023 to a floor of 18 with limited exceptions for 16 and 17-year-olds. Ohio's current minimum marriage age is 17 with parental consent, juvenile court approval, and conditions. Senate Bill 341 would raise Ohio's marriage age to 18 with no exceptions. It passed committee unanimously and is currently stalled on the Senate floor with no scheduled vote. Its sponsor is State Senator Lewis Blessing. The Columbus Dispatch has documented multiple teenage marriages within the extended Siders family. Fraidy Reiss, founder of Unchained at Last, is a forced marriage survivor who argues all marriage under 18 is forced marriage. What is theory? Whether Elizabeth Siders herself was coerced, trafficked, or a victim, a question her own attorney has said he cannot yet answer, and which this episode does not claim to. Whether SB 341 will pass this session, and the precise figures in the federal trafficking data which deserve primary source confirmation. What is invention? Any specific claim about ages or pairings in the family marriages beyond what documented reporting supports. I've deliberately not repeated the unverified versions, and neither should anyone else. And any assertion that Elizabeth's individual marriage has been legally determined to be trafficking, it is not. If you suspect a child is being harmed, forced toward a marriage, or endangered, the National Human Trafficking Hotline is 1-888-373-7888, and Ohio's Child Abuse Hotline is 1-855-OH-CHILD. And if you are an Ohio resident who feels something about a bill that would end child marriage in your state, Senate Bill 341 responds to exactly one thing, and it is not outrage in a comment section. It is a phone call to your state senator. That is the entire mechanism. Unlike almost everything else in this case, this one has a lever the public can actually pull. One last thing before you go. For 6 episodes, the tragedy of this case has been about not being seen. 16 children nobody counted, a family that moved through the gaps between counties and agencies until they vanished from the record entirely. But the girl at the center of it was, in one moment, completely visible. On March 31, 2008, Elizabeth Siders stood in a courthouse in West Virginia, 15 years old and 7 months pregnant, in front of an official whose job was to witness and record exactly what was happening. She was not hidden that day. She was on the record. A government building watched a 15-year-old become a wife, stamped the paper, and let the car drive back across the border into Ohio. The system did not fail to see her that day. The system saw her clearly, and the law told it to look away. That is what a bill like Senate Bill 341 is actually about. Not the house in Vinton County. That horror was already decades downstream by the time anyone opened that door. It is about the courthouse in 2008, and every courthouse still open to a version of that day. It is about whether the next 15-year-old or 17-year-old gets driven across a line and married, legally, while everyone whose job it was to protect her stamps the paper and looks away. This channel is going to follow this bill the way it has followed everything else in this case, not for the outrage, but for the follow-through. Whether SB 341 gets a vote, whether it dies quietly in a recess, whether Ohio joins the states that have already closed the door. If you want to be there for that, subscribe and stay. 16 children were found in one room. It started with a 15-year-old and a car and a state line, and the law that made that drive worth taking is still, tonight, on the books. I'll see you on the next one.